Greetings and welcome to Lecture 3 of Company Law Lecture Series, brought to you by Simplified LLB Law Lecture Series. My name is Ayub Okayo, and today I'll be taking you through two major topics. One on alteration of company status, where we will discuss how a company can alter its status, alteration of articles, and memorandum of association. Our second topic for today will cover foreign companies, especially their registration process under the Kenyan Companies Act of 2015. Welcome. Let us now learn these topics together. Now, how can a company alter its status from being registered as a private company to a public company? So, Part 5 of the Companies Act provides for all the alterations of a company on how it can change its status after the registration. So Section 70 to 76 provide for how a company can alter its status from being a private company into a public company. Of course, remember we talked about the private company and how it's restricted, including the a requirement on the advertising their shareholding. Of course, they cannot trade on the Nairobi Stock Exchange market. Also, we have the change of public company into the private company, and that is covered under Section 77 to Section 81 of the Companies Act. If this happens now, a public company which could have been freely accessible with regards to investment by the um, shareholders, freely transferable of their shares, will now be limited to a private company, which we already discussed. Then there is Section 82 to 84, which talks about how a private limited company can be altered to an unlimited company. Remember, we said that a limited liability company, the shareholders of that particular company are limited to only their capital subscription towards the company. And in case of anything, in case of insolvency, then the liability of the company can only be absorbed to the extent of the share subscription, including the unpaid capital, or rather unpaid shares. Now, what about the company being unlimited company to a limited company, especially the private companies? It's covered under Section 85 to 88 of the Companies Act of Kenya 2015. A public company can also be converted into a private unlimited liability company, which is covered under Section 89 to 91. Now, it's important for us to know at the moment when we are altering the status of a company, there are a few things that will need to be amended. And those amendments must be done within the confines of the Companies Act. And also, these amendments must be registered with the Registrar of Companies after the alteration. But before we go into that, let's first have an overview of the Memorandum of Association of a particular company. So we discussed in our previous lecture chapters that there is a memorandum of association and we also have the articles of association. Now, memorandum of association is a document that contains all those conditions or the required uh, documents that are required under Section 12 of the Companies Act for one to register their company. So there is no specific order on how this has to be relayed, but um, there are those requirements that a memorandum of association must have, especially the elements that must be reflected within the memorandum of association. And this memorandum of association is the bedrock of any company, as it stipulates um, the a major or the aspects of the company, especially the objects why this particular company has been formed. The memorandum of association also, it lays down the entire structure of the company, how the company is going to be, um, uh, what the company is going to do, and the objectives of the initial subscribers of that particular company. Now, what are the major components or the contents of the articles? I mean, rather, the Memorandum of Association. So, the Memorandum of Association highlights these major themes, of course. They may have a little bit more depending, but these are mandatory as required under Section 12 of the Companies Act of Kenya. Now we have the name of that particular company. As we already said yesterday, that when you are launching the registration of a company, it must go with three names. And that is a clause that must be within that uh, memorandum of association. Now, other than the name of the company or the proposed name, we also have the registered office. A clause must expressly state the registered office of that company. And of course, where they intend to carry out their businesses. Also, the articles of, I mean, rather, the memorandum of association must also have an article or a clause which will discuss the objects of that company. So, the objects of the company, these are the purpose why the company is being formed. If a company is, let's say, um, a commercial business, then it will indicate the nature of that commercial business of that company. If it is a company which relates to maybe um, maybe importation of any of the goods, they will have also to indicate that this is a company that is going to be dealing with importation. If it is importation of vehicles, they have to indicate importation of vehicles. If it's in the banking sector, they will have to expressly indicate now which scope on within the banking sector that this company will uh, be operating. The memorandum must also indicate the capital of that company, especially if it's limited by the shareholding. So it has to indicate uh, the, the statement of capital. It must be also relayed at the same time when you are applying for registration of that company. So you have to state this is the the total capital which the company intends to operate, and of course the shares, how the shareholding has been divided, and also it will um, look at the nominal values of those particular shares as um, required by the law. In addition to this, the liability of members, remember we talked about this yesterday, the liability of the members will also be um, important to be included as one of the clauses, whether company is unlimited liability company, whether it's a liability, unlimited liability company or limited liability company. It will also be included. And if it's a public company or a private company, it will also be included within the memorandum. Um, how members can subscribe? towards the company should also be one of the clauses, and several other elements that may be deemed fit during the registration process. Now, what about the articles of association of a company? As opposed to the Memorandum of Association, which governs the outside of operation of the company, the Articles of Association deals with the internal management of that particular company. So all the affairs of the company on how the company should be run, both by the management or the directors or any other dealings within um, the operation of the company will be regulated by articles of association. So the articles of association, those are rules, the guidelines, or the regulations that a company uses to manage its internal affairs. Now, what are the contents of that articles of association? What should be included within the articles of association? So here, articles of association must include share capital rights of the shareholders. It has to expressly show that, including the variation of the shares. We shall discuss further the issues on the classes of shares and types of the shares that members can subscribe to in our next chapter when we'll be looking at the membership of a company. The the articles of association should also include the transfer of shares. How can the shares be transferred between the shareholders? And also how the shares can be called up, the alteration of the capital. Remember, the capital of a particular company is must be well prescribed, and any alteration on that particular capital must be um, uh, must be amended within the confines of the law and is strictly monitored. And at the time when amendment happens, it must have a special resolution to come up with that. And other than just a special resolution, within the corporate governance structure, there are the procedures on how there can be an alteration of the capital of a particular company. The articles of association will also feature things like how the general meetings will be conducted, the procedures, the voting rights of the members. It will also capture the things to do with the directors of the company. How are they appointed, their remuneration, the qualifications, the powers that are given to them, and also how the board meetings can be conducted. Now, other than this, we also have the issue of dividends, how dividends can be divided between the members. It's also captured within the Articles of Association. The accounts of this particular company will also be captured, including the audit and also the borrowing power of that company. Who is authorized to borrow and to what extent can we borrow? To which kind of money, the leverage position of the particular company, and how much they have been allowed to borrow from outside to facilitate the running of that company. Um, the Articles of Association will, of course, also look into the procedure for winding up in case of the insolvency of that company. So all these things are captured within the Articles of Association and many more, depending on how the parties may wish or rather the founders of the company will wish to include. It's worthy noting at this stage that articles of association can be generated from the model articles, and at times, articles of association can be drafted from the scratch by those promoters who intend to subscribe or rather to bring about the registration of that company. And it's not very difficult, as we will see with regards to the alteration of the Articles of Association. It's not very difficult to do an alteration, as it requires uh, a general meeting where a special resolution can be passed to alter and a clause within the Articles of Association. Now, uh, what about looking at the difference between the Articles of Association and the Memorandum of Association? So, with regards to the Memorandum of Association, this is a charter. This is what constitutes a company. In short, everything that is required to put a company in place normally comes through the Memorandum of Association at the charter of that particular company, which directs on the objects and purpose of that particular company and the relationship with the outside world. On the other hand, the Articles of Association here, they are only internal regulatory mechanisms that a company normally comes up with, that is more of a subsidiary or an addition to the memorandum of association of that company. So those are the internal governing rules and regulations for a company. We can also call it the constitution of that particular company. Another element that may be worthy distinguishing between the Memorandum of Association and uh, the Articles of Association is that the Articles of Association um, defines the Articles of Association define the scope of the activities that the company will be engaging. While on the other side, um, the Articles of Association rather looks at how the rules within the company will be followed on making sure that they fulfill the objectives of the Memorandum of Association. Um, the Memorandum of Association is also supreme document of the company, as opposed to the Articles of Association, which is a subsidiary document or subordinate document to the memorandum. It is work is mostly to look into the conflict and also the management process. And in case of any conflict between the Memorandum of Association and the Articles of Association, then the Memorandum of Association will prevail. Lastly, under these differences, where okay, in the event of alteration, the articles of association are easily altered. In a general meeting, a special resolution can be passed to alter an element of the articles of association, as opposed to the memorandum of association, which is strictly restricted, and to some extent, some parts of that alteration of memorandum of association will require parties to uh, make sure that they have complied with the, the already existing memorandum of association and file the same with the registrar of the parties. Now, how do we alter an article of association? So, articles of association can be altered through a special resolution as coded under section 22 of the Companies Act. Now, the procedure for alteration of a company's articles of association, you can find it under section 22 to 24. There is, however, an important part for us to understand that Following the alteration of the Articles of Association, the company must launch this with the registrar of companies within the 14 days as required under Section 14. Failure to do this can attract a fine worthy or up to 200,000 Kenyan shillings. So, when making an alteration on the Articles of Association, there are boundaries that must be there are boundaries that are been demarcated, that the Articles of Association, when altering those articles, you must adhere to. So one of these is that the alteration must not be inconsistent with the Act, which is the Company Act of 2015. It should not alter inconsistently with the article. I mean the Act, the Companies Act of 2015. At the same time, it should not conflict with the Memorandum of Association of that particular company, and it should not be maybe the alteration should not also be done um, illegally, or it should not be done for an illegal purpose, and it should be made within um, it should be made within the special resolution. So the special resolution must be the one which will resolve on which elements to be altered and how it should be altered. And of course, the special resolution comes with more than a two-thirds of the members voting to make this kind of a resolution. It's also important for us to know that any alteration of this company should not be to the beneficial of an individual person, but rather it should be to the benefit of that company. And it will be it will be unlawful if this alteration will be done to increase or to alter the liability position of the members. Remember, we said that liability of members is either limited or unlimited. So if you're altering the Articles of Association to say members' liability was limited, now we're making it unlimited membership, then um, the liability of the company will not be altered to change the position of members. And of course, you cannot do an alteration of the company's Articles of Association to expel a member from being a member of that company. Now, what is the general rule with regards to the management of the company? Remember, a company is managed through the Articles of Association. As I already said, this is the constitution for the internal management of a company. We have a doctrine which is called the Doctrine of the Indoor Management. And that doctrine requires that the company should be run within the confines of the Articles of Association. So we leave the articles to dictate on the boundaries of all the managers, the directors, and all those that deal internally with the company. However, it's also important for us to know that the Articles of Association and Memorandum of Association, these are public documents and they can be accessed at the registered office of a company. And as such, there is a duty of every person to be able to read the Memorandum of Association and also the Articles of Association. However, one is not bound to look into the internal management structure or internal governance of that particular company, and it will not be in any it will not be of any use to look into the internal affairs of the company, as the law protects the internal management of that company. And that is under the doctrine of indoor management. However, There are instances where the indoor management doctrine can be varied or rather exempted. So there are some instances where we can say, look, uh, we are not supposed to look into how the government, or I mean, how the a company is running its own affairs. Maybe let's say a shareholder is trying to look inside the company to see if the managers or the directors are running the company within the confines. Their say is only left to the general meeting. So whenever they have any problems with the management of the company, they should wait until the um, they should wait until the general meeting or any special meeting that's being called for members to come up and contribute towards the affairs of the company. But other than that, they are precluded from looking into the internal management and governance of the company unless they are questioning the dealings of that particular company through a general meeting, which is normally called for yearly. We will, of course, discuss much of the options on the general meetings and the powers of the shareholders in another topic. But on exceptions to the doctrine of indoor management, we have a few things that may call for an outsider to maybe um, uh, question the operation of the company or the internal management of the company. And such exceptions include the knowledge of irregularity. If you already see and you know that there is an irregularity which is being carried out on the name or in the name of the company, you can flag that one out. Of course, if there is also negligence and or there is forgery, and in some extent also where some of the actors they are going beyond their apparent authority or the authority bestowed to them through the articles of that particular company. So that's how we can maybe question the internal governance or internal management of a company. Other than that, the company is left to those who have been given the powers through the Articles of Association to run it, and that is the board through their directors and also the management and other employees as have been um, entrusted by the company affairs. Now, let us look into another chapter, which is a chapter of 4 on the foreign companies. Now, this is a short chapter. I will just run it through to highlight on a few important things on the foreign company registration in Kenya. So, when you are intending to maybe register an office of a foreign company in Kenya, or registering that that particular company of the foreign company is to operate or to do any business within the government, I mean within the country of Kenya, you must adhere to the requirements of Section 974 of the Companies Act of Kenya 2015. Now, the Section 3 of the Companies Act um, defines the foreign company to be that particular company has been um, which has been incorporated in a different jurisdiction other than Kenya. So if the company has been incorporated, let's say, in the UK, then that qualifies to be a, a foreign company. And as such, it must make sure that it is registered under the requirements of Section 975. So Section 974 um, provide for uh, the company and the company a requirement for it to run within Kenya. And it can be a company which has already been registered or a company which has applied for registration and uh, uh, is pending the it's pending the registration by the registrar of companies. So there is that particular process that has to be fulfilled for a foreign company to be fully registered within the Company Act of Kenya 2015. So during that registration process, there are several things that must be launched to um, make sure that the company is registered. So we have a certified copy of the Articles of Association or the constitution of that particular company from wherever jurisdiction they come from, and must also launch with the registrar a certified copy of the certificate of registration or incorporation in the jurisdiction where it was incorporated. It must also have the list of shareholders, the list of directors, and any details with regards to such persons, including their personal details, their addresses, if they are in existence. There's also a requirement under the Companies Act that um, if the company has a registrable charge, it must disclose that to the registrar of companies in Kenya. And now, the moment the registrar of companies identifies that all these requirements under uh, section 994, I mean, rather 974 to 976, then the registrar will now go ahead to register this foreign company to operate in Kenya. And as a way of registration, it will be issued with a unique identifying number, uh, just like a local registered company or a Kenyan registered company, where it also has that unique identifying number. This foreign company, the moment the registrar certifies that they have fulfilled all the requirements, they'll be issued with a unique identifying number. And then following that, they will be issued with a certificate of compliance for that particular registration. Section 977, however, depicts a situation where um, the company registered in a different domain, in different jurisdiction, may register in Kenya under a different name. Let's say, for example, you can have Diageo UK PLC, and then you may have Diageo Kenya Limited as an agent company or the same company, which is a foreign company, but now registered under a little bit different name from the one which was registered in a different jurisdiction. So you may have Diageo UK as the parent company, and then we have that for in Kenya, that particular company is called maybe Diageo Kenya Limited. So that can be an alteration of the name from that particular name that was uh, given during the incorporation in a foreign jurisdiction. There is also another requirement under Section 974 that a company which can be deemed as a foreign company, for it to be registered in Kenya, it must have at least one natural person. Remember, we said yesterday, or rather in our previous lecture, that the registration of the company can be done um, can be done um, through But I mean, the subscription of the company during the registration can be done by another company. It can be owning shares within a different company. So let's say Diageo UK owning like maybe 60% of Diageo Kenya Limited. And if so, at least one representative of that company must be a natural person. We cannot only have like um, only Diageo company having being the official representative of this foreign company that's being registered. So we must have at least a natural person who is acting as a representative of that company during the registration. So that's it for today. It is the end of our lecture three. We will now look into our lecture four next lecture recording. And in this lecture four, we shall cover execution of documents by companies. How do companies execute their documents? And also, we shall cover the company members. How do we get the membership of a particular company? So until then, thank you very much and see you in our next lecture series.